And we are recording.
Thank you. Okay, so hello and welcome to our Regulation and Discipline Committee meeting of the State Bar. As a reminder, this meeting is being recorded. Justin, could you please call the roll?
Sure. Broughton.
Here.
Chen.
Here.
Cisneros.
Here.
De La Cruz.
Here.
Duran.
Here.
Selig.
Here.
Shelby. Soul.
Present.
Stallings.
Here.
We have a quorum.
Great, thank you. The next item on the agenda is the call for public comment. For those of you who are participating by Zoom, you can use the virtual function to raise your hand. It's a hand icon at the bottom of your screen. If you're on the phone, you can participate by pressing *9.
Okay, it appears we have one member with their hand raised. Mike Muter, I have unmuted your mic. You will have 3 minutes.
Great. Thank you very much. Good afternoon. My name is Mike Muter. I've been an attorney for 29 years with California Rural Legal Assistance. I'm currently CRLA's Deputy Director, and I'm based in our CRLA office in Salinas. I'm requesting that this committee add an item to the agenda of your next meeting. The requested agenda item is the impact of the timing of bar failure on the Registered Legal Services Attorney Program, the RLSA. The very brief basis for this request is that the RLSA has been vital in efforts to recruit and retain attorneys to provide much needed legal services in rural California, but a specific RLSA rule of court 9.45C7 creates a burden that from CRLA's perspective arbitrarily limits the full intended use of the RLSA program. That limit is attorneys licensed in other states who apply for and then are granted RLSA status and then take but fail the California bar exam are appropriately allowed to maintain their RLSA status while they continue to attempt to pass the California bar. But Rule 9.45C7 prohibits attorneys licensed in another state who are otherwise eligible from even applying for RLSA if they take and fail the California bar exam prior to applying for RLSA status. We urge you to consider amending or eliminating that rule, or in the alternative, to at minimum allow folks who are currently provisionally licensed lawyers under the bar's provisional licensure program that was set to sunset on June 1st to apply for RLSA status regardless of 9.45C7. Finally, speaking of the provisional licensure program that started in 2020 pursuant to Rule of Court 9.49, this program has been immensely valuable to low-income communities and IOLTA-funded programs across the state, and especially beneficial to CRLA's provision of legal services to rural California communities. We strongly support the extension of the PLP sunsetting date through June 2023, or at least December 31st, 2022, to allow provisionally licensed attorneys in good standing to maintain their provisional status to continue so they can provide vital legal services as they make another attempt at passing the California bar to ultimately become fully licensed California attorneys. Thank you for your consideration of these requests.
Thank you.
Thank you, Mr. Muter.
And there are no more hands raised.
Okay. Well, with that, we'll move on to the chair's report. I only have one very brief update, which is to note that on the board, the full board's agenda is approval of a contract for a new SDTC administrator. Jose Cisneros and I are pleased to announce that Stacia Laguna has accepted our offer to join us as our new SDTC administrator. She comes to us with significant experience, having been trial counsel with OCTC and also counsel to the State Bar Court. And we're really excited to have her on board. And she'll begin June 1st, I believe. Okay. We have one item on the consent agenda, which is the open session minutes. Does anyone wish to pull an item off of consent? Okay. Are there any corrections or modifications to the minutes? Not seeing any. May I have a motion and a second?
So moved.
I'll make the motion.
I'll second Duran.
Okay. Motion by Cisneros, second by Duran. And Justin, could you call the roll, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Aye.
Selig,
Yes.
Shelby, Sowell,
Aye.
Stallings.
Yes.
That is 7-4-0 against. The motion passes.
Great. Okay, next we move to our regular items. The first item is proposed amendments to rules of procedure of the State Bar, Rule 5.127, public and private reprovals, as well as Rule 5.155, actions by the review department. This is a return from public comment and request for approval, and we will have a presentation from Erica Doherty, as well as Michelle Crampton, the clerk of the State Bar Court.
Good afternoon and thank you. Can you hear me okay?
Yes, we can.
Great, thank you. So in brief, there are two rules of procedure that we are requesting permanent adoption of. The first being amendments to 5.127A. That will clarify when reprovals become final, clarifying that essentially it allows time for a party to request an appeal in reproval matters. The second is an amendment to Rule 5.155F, as in Frank. And that is to clarify that any hearing judge can be temporarily elevated to the review department if necessary based on a disqualification or unavailability of a review judge. Both these matters were issued for a 45-day public comment period. The State Bar received one comment from the LA County Bar Association Professional Responsibility and Ethics Committee. They were in favor of 5.127A's amendment, and they were essentially neutral on the changes to 5.155. And I'm happy to answer any questions, but that's essentially it.
Okay. Any questions?
This is Brandon. I'll move the item.
Duran, I'll second.
All right, Justin, could you call the vote, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Aye.
Selig,
Yes.
Shelby, Sowell,
Aye.
Stallings.
Yes.
That's 7 votes for, none against. It passes.
Great, thank you. Thank you for the presentation. Okay, next item on our agenda is a request for approval of proposed revisions to Monterey County Bar Association's mandatory fee arbitration rules. This is a presentation by Isabel Liu, an attorney from the Office of Professional Competence. Ms. Liu, the floor is yours.
Thank you. Good afternoon, everyone. My name is Isabel Liu. So item 3B is the request for approval of proposed revisions to the Monterey County Bar Association's mandatory fee arbitration rules. So the Monterey Bar's rules were last approved in July 2013, but the bar has not offered fee arbitration since 2017. So they would like to resume offering fee arbitration, and in the meantime, they've updated their rules of procedure. So most significantly, they are expanding their filing jurisdiction to include both Monterey as well as Santa Cruz County. And then they also made clarifying edits to their filing fee schedule as well as the filing fee refund schedule. And they've updated a handful of rules to reflect the State Bar's current model rule language, as well as adding rules on electronic service and video conferencing. So I would be happy to answer any questions about this item or the fee arbitration program in general.
Questions or comments? Okay, not hearing any. Do we have a motion?
Hi, it's Jose. I'll make the motion. I'll second.
A motion from Cisneros and a second from De La Cruz. Great. Justin, could you call the vote, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Aye.
Saleg,
Yes.
Shelby, Sol,
Aye.
Stallings.
Yes.
That is 7-4, 0 against, 1 absent. It passes.
Great, thank you. So that's the end of our open session items. We will move to closed session pursuant to Government Code Sections 11126A1 and 11126C2. We'll be discussing Rule of Procedure 2201, the case status update, and discussion regarding the Rule 2201 program. And Justin, remind me, do we have links to the closed session?
Yes, I just sent the link to everyone's email for the closed session. So
I'm just realizing I'm going to need technical support in here to help me change the camera over.
Highland, this is Louisa. I have IT coming down right now.
Okay, thank you. All right, I will see you all in closed session.
We're recording again.
Great. So, and we don't need to take roll again.
I don't believe so to adjourn.
Okay, so we are back in open session from closed. There was no reportable action from our closed session. And with that, we can adjourn our meeting. Thank you, everyone.